TDO or an ECO. Oh, we did our best content already.
Yeah.
Anyway, so it's good to know that this is a sequence, but it can start at multiple points in the sequence, just depending on the details of the person and the situation and their crisis.
I'd also add, somebody can exit this process at any of these steps as well. So once you start, doesn't mean you have to go through the client, respondent, consumer has to go through the whole process. They can exit at any of these steps as well.
And there's different ways that can happen depending on where they are, and we'll talk about a lot of those ways as we go through. But that's a very good point. So then we can, I guess we've said a little bit of some of this, the crisis, right? Like a crisis happens, and what is crisis? Well, it depends on the person, depends on their situation, depends on lots of things. But really it comes down to, if someone tells me they're in crisis, they're in crisis. Now, what happens next depends on the details, but it's subjective, right? If someone says they're unsafe, or a reliable source around that person says they're unsafe, that's crisis. And then we got to figure out what to do. And one option is that ECO.
So the ECO is governed by Virginia Code Section 37.2808. As Kurt was saying, the ECO gets the person to a convenient location for an assessment to determine if there's further treatment or hospitalization necessary, what's going on. The convenient location in the Region 10 area is UVA Hospital. There's Martha Jefferson, but the convenient locations determined by the magistrate, and all of the resources needed are at UVA Hospital. So we will send anyone who isn't already at Martha Jefferson to UVA Hospital. If somebody's already at Martha Jefferson, we will keep them there, but everybody else will be sent to UVA Hospital in the Charlottesville area. In Goochland, because I know we have people from Goochland on here, it's usually Henrico Doctors on Pyram Road is the convenient location. Now, again, the convenient location is determined by the magistrate, and there could be a reason that somebody goes to a different hospital, but this is just the typical general rule or procedure that we go by. But it doesn't mean that, the ECO isn't good if the person does go to Martha Jefferson or for some reason sent to Culpeper Hospital or somewhere else.
Right. And there are scenarios and discussions, I think, that many are aware of, that in the future there may be other convenient locations, and those could be developed, they could be implemented, and then the magistrates would have to determine whether or not that they want to put that new place, whatever it may be. But for the meantime, our local practice and systems are built around UVA emergency room. So then we have to conduct an evaluation that's mandated in the code. In fact, really, in a little bit, I'll talk more about my team, but the only reason Region 10 Emergency Services exists is because of this section of the code. The CSB must evaluate someone who's on an emergency custody order. So at the end of the day, if my team does nothing else, we have to do this. We are certified by the Department of Behavior. The clinicians on my team are certified by the Department of Behavioral Health as pre-screeners, meaning we've gone through specific training, not only around risk assessment, but also around the code and the criteria and the processes. So it's one thing to say, hey, Jane Doe says she's suicidal, she's not safe, but that doesn't necessarily mean she meets the commitment criteria that we'll go through in a second. So we're trained on risk assessment, we're trained on crisis intervention, and we're also trained around the specific code elements and commitment criteria to determine whether or not Jane Doe needs to be in the hospital against her will, or if there's some other legally appropriate option. So we conduct that evaluation, we complete the documentation, and determine whether or not we believe Jane Doe, or whoever the person may be, meets commitment criteria. And if we do, we have to find a facility. And that's a really, really important piece. I'll mention multiple times, an ECO can exist just because of risk. A TDO can only exist if there is risk and an accepting facility. And that second part, as many of us know, and we'll talk about more later, can be a challenge, can be a serious challenge. But once we find an accepting facility, again, we'll talk more about what that means, then we can petition the magistrate for a TDO for the respondent, the individual, the patient, the consumer, the Jane Doe, and say, this is how they meet criteria, this is where they're going. And then the magistrate can determine whether or not they hear evidence that allows them to issue the order.
So then there's the TDO, governed by 37.2809. In the steps that we showed you in the earlier slide, there was the CSB evaluation and then the TDO. Now, we must have the evaluation to even be able to consider the TDO. So those two are the only things that absolutely have to have an evaluation to consider a TDO. The TDO is, we'll go over the code, but we don't, whereas for the ECO, we'll determine the location. For the TDO, as Kurt said, they will determine where the person is, where the bed space is for the accepting facility. Here, we're determining whether further treatment.
Caitlin, mute yourself on the computer.
I was going to say, can y'all mute?
Somebody mute.
I heard you.
Thank you.
Thank you. Whether there's need for further treatment and evaluation based off of the information now from the pre-screen, from the certified pre-screener, and the legal criteria. There are two exceptions that allow us not to have a pre-screen, which is, or a recent pre-screen within, the last hour or so, is if one has been done in the last 72 hours, we can use that pre-screen to move forward with the TDO hearing, or what we call is the Hannibal Lecter exception, which is the person is so dangerous to anyone associated with conducting an evaluation that one cannot be conducted. But I think those facts in itself will tell us a lot of what we need to know for the criteria, but they don't need to have went through and asked all of the questions on the evaluation. The pre-screener would give us the information, the facts that, a significant physical or psychological or medical risk, well, what the code says on the screen, exists, and then we can make that determination.
Yeah, and I don't think we've ever used that. Well, there might have been one time, and honestly, it was more of a procedural kink that made it appropriate. But as Adnel said, if there was someone that was too unsafe to be assessed, I would say that's the assessment. We would have to get the information that tells us they're too unsafe to be assessed, and that would be the information we put in the pre-screen. And I would call that an assessment. The 72 hours, it's worth a couple seconds on. I think that's an interesting thing. Risk assessment research is pretty clear that it's really hard to do good risk assessment outside of 48, 72 hours. Immediate risk assessment, right? Like I can tell if someone's not doing well, but to be able to say something bad is likely to happen soon, it's really, really difficult, empirically proven, to say something bad is likely to happen in the next 2 weeks. It is possible to say something bad is likely to happen in the next day or two, which is where that 72-hour number, well, I think one of the reasons that underpins that 72-hour mark. And just, for the clinicians on the line, or for anyone who's interested, where that comes into play for us, often, I'll assess someone, and if they didn't want to stay on their own, I would TDO them. The risk is there. It is significant. I don't feel safe with them leaving, and they're kind of on the fence. Then I'll say to them, look, you can't go home because of these reasons. I'm worried about you. These are the reasons that I don't feel safe with you going home. I hear that you might want to stay at the hospital. That would be great. Okay, I'll stay. All right. But I also want to be transparent with you and let you know, if you change your mind in a couple hours, if you change your mind tomorrow morning, I don't need to come back, because this document that I'm writing is good for 72 hours. And, what's the purpose of that? I want anyone in crisis, me, you, Tom, to have agency over their treatment, but we also need to make sure they're safe, and we also need to be transparent. And I think it also helps in those cases drive home, right? Like sometimes it's hard to really grasp the severity of the moment, and having someone, frankly, with a little bit of authority in that position at the time, but also with some empathy to say, this is a big deal. So So go get some help. And I'm just underlining and underscoring how serious this is, that all the hospital has to do is call me, and I'm going to call Avnel and say, Jane Doe can't go home just yet. So we tried to actually use that almost as a clinical tool in some cases. But the truth is that if I evaluate someone on Tuesday and they meet commitment criteria, I don't need to screen them again on Wednesday or Thursday. I might choose that as might make a clinical judgment to do that if there have been changes, right? Their sister showed up from Colorado, and now there's some new potential resources. Maybe I do want to reassess. But if nothing's changed except for Jane Doe wanting to leave the hospital, we don't need to reassess within the first 72 hours. You want me to do this? You want to do this one? All right. So yeah, I guess that's right. So a TDO most times, and we'll talk about exceptions a little bit later, ends with a commitment hearing. Again, a commitment hearing is presided over by a special justice. So that's not Avnel's crew. That's someone else that's appointed by a circuit court. Circuit court. In our area, it's Ray Clark. He's done it since 1932, I think, and hopefully we'll do it for another 52 years because I don't know who else will do it.
Is it Andrew doing it?
He fills in sometimes, but I don't know if he would hang around. Anyway, if you've met Ray, you have an opinion about him one way or the other. Mine is very high, but that's beside the point. But each special justice, as each judge, runs their hearings the way they see fit for the code. But the bottom line is they need to have the pre-screen. They need to have an independent evaluation by a clinician who they've appointed for this role. So someone who understands the code and criteria like my team does, but doesn't work for the CSB and doesn't work for the hospital. So an independent person assesses the individual within the TDO timeframe and provides a report to the court, to the special justice. And then they receive testimony. There's also a lawyer appointed to represent the person, so their rights are protected and they're advocated for in the hearing. And then they receive testimony they want to receive that they feel is appropriate. And then they decide. The person could be released, commitment criteria is not met. The person could be placed on a commitment order for up to 30 days. They could also be placed on a voluntary commitment, meaning they say they'll go, but the judge, for some reason, wants them to be on a voluntary commitment, which means they can't leave for the first 48 hours. No, they can't leave for the first 72 hours. And then after that, they have to give 48 hours notice. So that essentially means they can't just up and split, but they are able to sign themselves in and be a voluntary patient. It's kind of a quasi state, but it's in the code. So it is what it is. So that's that commitment hearing. The initial commitment is for up to 30 days. If after 30 days, Jane Doe is still at the treatment facility and still is unsafe to go home, there has to be another hearing, a recommitment hearing. At that point, the judge can sign an order for up to 180 days. The judge doesn't have to. They could write it for 6 hours. They could write it for 4 days. They could write it for as many days as they want, but they can't exceed 30 on the initial commitment hearing and 180 on the any recommitment hearings. All right, the commitment criteria. This is the meat of it all, right?
Yes. So commitment criteria. This is the same criteria for an ECO, a TDO, and for a commitment. So this Jane Doe is going to be evaluated on the same criteria multiple times for if Jane Doe goes through the whole involuntary detention / commitment process. Why? Because we want to make sure, right? I can only guess to what the legislature wanted, but this person has not done anything, or in this sense, if they're in a mental health crisis, anything criminally wrong. Now, other criminal things may have happened along with it, but when we're considering an ECO, TDO, or commitment, we're trying to get this person assistance, right? Trying to get them help, trying to keep them safe. So how long can you deprive somebody of their rights because we're it's an involuntary detention. So we're telling this person, you cannot go home or where you want to go, you have to go here. And there's going to be people asking you a bunch of questions, and we're going to determine whether or not you're safe. So how long can we do that and why? So the language on this slide is exactly what the code says, but we break it down into 4 criteria. There needs to be a mental illness. Due to the mental illness, there's a harm. Due to that mental illness, there's a lack of consent. The person's unwilling or unable to consent. And due to this mental illness and the harm caused from it, there's a need for hospitalization or treatment. So we'll go into each criteria.
We'll go through each 4, and it's important to note that the code does not see them as sequential. They don't necessarily go in an order, but from a clinical standpoint and from training, I do see them as sequential. At least when I'm staffing cases or I'm doing my own assessment or I'm staffing cases with my colleagues, I think about them in the order that we're going to show. And you'll see at the top of the slide, the top of the slide, there's a italics question. That's not in the code. That's how I think through the criteria. And I've used this framing with other people and people say it's helpful, so I put it in here. But so that top line is mine. The rest of it is Avnel's. But we need to start with mental illness. If there's no mental illness, we're done, right? Like there may be harm, there may be problems, there may be all kinds of things, but if it's not based on mental illness, they don't meet the criteria.
Right. And that mental illness, it could be a diagnosed mental illness or symptoms of a mental illness. So we'll get into how these processes are initiated. But if friend comes in to the magistrate's office to get an ECO, they may not know that their friend is diagnosed with a mental illness, is diagnosed schizophrenic or diagnosed with, depression. They just might say, well, he in the past couple of days, he's just really changed. He lost his job. He's sleeping all the time. He doesn't like doing the things that he usually did. Symptoms of a mental illness are enough. If you look, the code that defines mental illness is very broad, very broad. So if we can we need facts. So for all of these processes, when you're coming in front of the magistrate, we need the facts. Somebody can't just come in and say, oh, they have a mental illness, I need an ECO. No, we need to know the facts of what is what's occurring. So this is the definition of mental illness. If we're hearing the symptoms or hearing of behavior or actions, we're going to go to this code to see if it meets. And it's very broad. So it includes substance abuse and dementia. Now, substance abuse, for those of us in the city of Charlottesville, we have UVA, right? The students came back this past weekend. The freshman who gets drunk for the first time we're not going to say, oh, that's substance abuse. Substance abuse has to affect someone's daily life, work, and relationships. So we're going to need the facts of, that regular that we all see. They've been drinking for 20 years when they are not able to keep employment, or when they're not drinking, they are. When they are drinking, they cannot. All their family has abandoned them. Things like that to qualify for substance abuse. Now, I know dementia is a medical diagnosis, but again, go back to the code. The code provides a specific definition for mental illness for these processes, and dementia fits in there for mental illness for the involuntary detention process.
But so then to move to the next part, while dementia and substance abuse are in there, as Avnel says, there are certain mental health presentations, behavioral health presentations that might fit, but we then got to have the other criteria as well, right? So back to my question, all right, mental illness, let's say we've established that, are they at risk of harm due to mental illness? The student that got drunk for the first time, well, I wouldn't say substance use disorder, but let's say he got drunk for the first time and is overwhelmed being away from home and is now impaired because he's drunk and he's going to jump off the train bridge. Well, I probably wouldn't put substance abuse down. I'd probably put adjustment disorder down because he's adjusting to a big life change and isn't adjusting well. So yeah, alcohol is a factor, but I'm not going to worry about that for the diagnosis. I am going to say that I could get to where I'm saying there's a risk of harm due to a mental illness that either is substance abuse or adjustment disorder or something else yet undiagnosed, right? So yeah, we got to go through all of them. So is there a risk of harm due to that mental illness?
Right, due to the mental illness. So my classic example.
I love it.
So
this is my favorite part of the presentation.
You know, I had somebody come into the magistrate's office one time, a guy, and he wanted an ECO against his brother. Said the brother has been diagnosed with bipolar and had punched him in the face and is acting just out of sorts. He needs an ECO. We need to put him, we need to get him help. So, and we'll get into this about initiation. The magistrate has to determine whether or not the person in front of us is a responsible person to petition. So in asking these questions, I'm asking questions to get to the criteria to get, is this a responsible person? So well, why would he just punch you? And I found out that the brother in front of me was punched because the brother he was trying to get the ECO against was sleeping. He was sleeping with his wife. That is not due to the mental illness. Yes, he has a mental illness. Yes, there was a harm, but they have to link together. Now, maybe criminal charges, but no, I'm not, put your brother where you're sleeping with his wife and commit for up to 8 hours due to that circumstance. So they have to connect. The harm has to be due to the mental illness. Now we break it down and we call it active harm or passive harm. Active harm, which is just more anecdotally known of, there's a physical harm. We always hear homicidal, suicidal, but it doesn't even have to be, like I said, a punching, some kind of a physical altercation, threat of physical altercation, some recent behavior that's going to lead to an active harm, cause harm to themselves or to another. But then there's also what we call a passive harm. Inability to protect oneself or inability to care for one's own basic human needs. So somebody who's in an active delusion, who's in the middle of Route 33 and thinks that they're in a forest, is unable to protect themselves. That qualifies as a harm. Somebody who's in their home suffering from mental illness due to the mental illness is basically like living in their own urine and feces, unable to provide for one's own basic human needs, not sleeping, not eating. Those qualify also for as a harm. Again, due to the mental illness, can be a harm. So it's not just homicidal or suicidal, and those are nowhere in the code. It's harm to himself or others, unable to protect oneself, unable to provide for one's own human basic needs.
And the passive harm is tricky, and there are many states that don't have that. They're looking at specifically suicidal, homicidal ideation or specific harm, and I think it's also worth pointing out. I think this would probably fall under passive harm, but there are other types of harm, right? So, sometimes when people are experiencing an acute manic episode, they can have very grandiose thinking and delusional thinking, and be convinced that they know that if they got to the Bellagio and put 10,000 on 42, they are going to win. And so they're going to get a credit card and they're going to go down to Cho and they're going to get a flight to Vegas and they're going to do it now. And if they did that, they would be $50,000 in debt due to the mental illness. Now, if somebody wants to recklessly go to Vegas, go for it. Mm-hmm. If somebody wants to recklessly go to Vegas because their thinking is impaired by a acute manic episode, that could be harm that would meet this criteria. Or maybe Jane Doe on the downtown mall isn't suicidal. Maybe she's irritated and agitated because of manic symptoms and is going into businesses and causing a ruckus, and she's about to get arrested. So she could have potential legal harm, not because she's making poor choices, but because her thinking and behavior is impaired due to her mental illness. So there are some types of harm that aren't necessarily physical, but could still have significant negative consequences for the person due to their mental illness. But when we get into some of the passive harm, what's tricky, and this actually maybe pivots into the next slide, there are times where we've been asked to see someone, well, they're delusional. They think there are bugs in their house. They should go to the hospital. And the truth is, maybe they should go to the hospital. Maybe as a human being, I want them to go and get treatment so that they can feel better and not think that there are bugs in their house. But when I talk to the person, they're like, yeah, there's bugs. Fine. Well, what do you do about the bugs? Oh, nothing. I just watch TV. They're fine. Why? I'm not sure that I see harm in there. When we get into the cases where there's delusional thinking or hallucinations or bizarre behavior or whatever phrase you want to put to it, as a clinician, I'm trying to draw as straight a line as I can from the thinking, the behavior, the symptoms to some kind of potential harm. Like Avnel's example, if somebody is walking down 29 and think they're in a forest, well, they're liable to get hit by a truck. That's a pretty direct line. I don't want them in a place where they could potentially get hurt. If Charlottesville PD calls and says, this guy has been in and out of every business on the mall and he's lucky nobody's pressed charges, I can draw a pretty straight line. Somebody thinks they have ants crawling around their apartment and they don't love it, but they're not going to do anything bad about it. I don't know that they meet criteria. So we try to really think about not just are there symptoms that would benefit from treatment, but are there symptoms that are creating harm where I'm allowed to force treatment on this person?
That's a great point, Kurt, because people can be mentally ill. We've had, somebody's walking on the downtown mall and they're talking to themselves. And, they're swinging their arms really fast and talking really fast and there's nobody there. Well, that doesn't mean that they need to be ECO'd. Now, maybe there is more information that would lead to hitting all of these criteria, but just that in itself would not lead to an ECO. We've had where, a family member who does suffer from a mental illness and maybe has stopped taking their medication. But when they stop taking their medication, they hear voices and opens all the doors in the house and turns on all the lights. That doesn't mean they need to be ECO or TDO. Mm-hmm.
And to be honest, there have been times where, we'll have a situation with someone and I'll turn to a colleague and with a heavy heart say, they don't meet criteria today, but they're gonna soon. And so I want to be able to intervene now before it gets worse, but I can't, right? They don't want treatment. And so I'm like, man, I just hope when we get there, it's not something really bad but there are times where it's not there and I can't, I could try to petition, but they won't issue and it wouldn't be right for me to petition if the criteria isn't met. So there are times where symptoms can be present, but we don't meet criteria. But I think this third criteria, I think is really in some ways the most important one. It's sometimes kind of overlooked, right? Like Jane Doe's walking down the downtown mall and is gonna kill herself. Well, we can I was about to say skip. We don't skip these, but we can pretty easily check all these boxes. But and again, when I talk about the pre-screeners in our service and what value we bring to this process, I think really rests in this criteria. Okay, Jane Doe, she's on the mall, she's suicidal, but maybe there's another way to mitigate that risk other than hospitalization. Maybe she can go and stay with her brother and he can lock up all the knives and she can see her outpatient therapist tomorrow and she can, whatever other things we can bring to bear. So it's not to say that she doesn't have a mental illness and there isn't a risk of harm. It's just to say that there is a less restrictive way to mitigate that risk and to provide treatment for Jane Doe that isn't a hospital. And so I think this is a misunderstood question. There's sometimes like, well, she's suicidal. She's got to go to UVA. Maybe not. Maybe there's another way to support Jane Doe and to mitigate the risk that we found in the first two questions. So we really try to look at, is this the only way to mitigate the risk and to give the person the necessary treatment for their current crisis?
When we're looking at it from the magistrate's, from the legal point of view, the code says there's a need for hospitalization or treatment. So the scenario that comes up a lot, and Kurt's right, like this box is usually pretty easily checked. But what if Jane Doe's in the nursing home and she suffers from dementia and she's fighting the staff and other residents? Well, we still need to, what is the need for hospitalization or treatment? Well, she's already on her medication or the medication that's been prescribed for her. What is hospitalization or treatment going to do for a dementia patient? A lot of times, nothing. There is no treatment. So that criteria may not be met. Now, not to say in every situation that because something else could be going on with that, you know, dementia is the first thing that somebody may speak of, or Alzheimer's, but there may be something else going on that needs hospitalization or treatment. But we're looking at this criteria to see what is there that need for hospitalization or treatment? What is sending this person to the convenient location or to Western State or Pavilion? What is that going to do? Where is that need? And we would need facts on where that need comes in.
And then the last criteria, right? So again, my build-up question, right? Is the person unwilling to volunteer or incapable of volunteering for the hospitalization that's needed to mitigate the risk that's due to the mental illness, right? So I pull all 4 points there together, and if they're willing to go, then they don't meet criteria. If they're willing to go and they have capacity to make that decision, then they don't meet criteria, even if all the rest is in place. Again, usually this is straightforward, but not always. Sometimes it can be kind of tricky. I think one of the trickiest scenarios we run into, and one of the things we look at when we consider capacity, is the ability to maintain choice, as the language that's in the pre-screen and some research. So if someone says, yeah, I'll go to the hospital. No, I'm good, I'll go home. It's a really big deal. Okay, you're right, I'll stay. I'll usually give 2. But on that third one, I'm going to go ahead and get a TDO, not to be a jerk, but just to take control of the situation, because that person, that ambivalence, that inability to maintain choice is making them unsafe, right? And so I want to remove the burden of having to choose from them so they can go and get the treatment that they need, right? And I've said that. It's like, look, you don't have to do anything other than just be. We'll take care of the decision. The hospital will take care of the treatment. You can relax, because when we're in crisis, it's hard to make good decisions. So there have been times where somebody's otherwise would have capacity, but they waffle. And after a couple waffles, it's time to move on. And again, that phrasing sounds kind of paternal, but it really is a clinical thing. If you're in crisis, you can't quite make and hold a decision, we can move forward. So, but yeah, sometimes it's clear, screw you, I'm not going to the hospital. Okay, I can check that box. Or it's pretty clear, where are you? Well, I'm in Colorado. Okay, we can check that box. But anyway, that's it.
Lack of consent, we're looking at the same thing. Where unwilling is pretty easy. Unable to consent, again, to go back to the point, we need the facts. So when you come to the magistrate's office, not just, oh, this person's in delusions, he can't consent. Well, what do those, you don't have to explain to us, what are the facts that lead to the determination or the conclusion that the person is unable to give valid consent? There's a case noted on the PowerPoint, Zimmerman v. Birch. That case is to highlight if somebody is unable to consent, they should be afforded the opportunity, and I'm cutting this part down a lot because we're almost already at an hour. Yeah. I usually go through the whole case and ask, what do you think? But kind of the 33 scenario I put out there. Mr. Zimmerman was out in the street in active delusions, was assessed by several different people out in the field. And everyone was like, okay, there's something going on here, something big going on here. He doesn't understand what's going on, what he's doing. Let's take him to the hospital. But then still had him sign some forms to say that he was voluntarily going to the hospital. And he was in the hospital for, I want to say, months ultimately, but every step of the way, he was always signing he was always given documents, consent forms, consent contracts to say, I'm here on my own free will. But he was unable, and everyone knew in the notes and such, when you look at the case file anyway, that he was not able to make a valid decision, unable to consent. So he should have been afforded the protections of the involuntary commitment process. Now, this isn't a Virginia case, so, but that he should have been given those protections, because as we went through in the beginning, there's all these points where you're assessed and you have all of these people checking and making sure that you meet this criteria and that we're depriving somebody of their rights all along the way for 8 hours, then up to 72 hours, then up to 30 days, up to 180 days. We need to make sure that, that it's a valid relinquishment of their rights. And he wasn't afforded that process. So this case is to highlight, if somebody's unable to give valid consent due to the mental illness, they need to be afforded the protections of the involuntary commitment process.
Yep, absolutely. Okay, so she's right. That's an hour, but it is. I mean, we have a lot of other content, but that is a really important hour, because there's not all the rest of it doesn't matter if we don't have a good grasp of the process and the commitment criteria that I think that drives that process. But now we are at a question spot. There's some new stuff in the chat. What do we got? Questions?
So there were two questions that came from Anna Mendez from Partners for Mental Health. First question was, who and how can somebody ask for an ECO through the magistrate's office?
We'll get to that.
Okay, very fantastic. We'll come to that. And then also, Anna was requesting information about, does somebody on the autism spectrum disorder qualify for somebody that is considered a mental illness? And so if you could answer that.
Yeah, we'll get into that more. But I think
that's fine. No, that's great. If it's farther into the details of the presentation, just make sure that we can come back to that.
Yeah.
And then
I would say, because this was an adult section and we're an adult, it does matter if you're an adult or a minor, if you're on the autism spectrum. As an adult, it's still considered. For a minor, and we'll get into it more, it's specifically excluded as a reason for mental illness. But we'll get more into that.
Well, but there
was another question
in
the main about how do you exit the TDO process.
Oh, right. Yeah. Well, one comment on the autism, I just will say generally, because dementia too, like intellectual disability, autism spectrum, and dementia, right, they may or may not fit at certain points, but when someone if that's the primary diagnosis, what I'm really looking at are the behaviors and the specifics of the moment, right? So autism may not qualify, but if a person's behavior is such that they are dysregulated and violent and cannot control their emotions and behaviors, then they might meet criteria, and the top line diagnosis may not be the autism spectrum. That may be present, but it might be an adjustment disorder, it might be depression, it might be anxiety, combined with the autism that's leading to behaviors that makes that person unsafe. So, and the same thing with dementia, as we mentioned before. Somebody might have dementia, well, psych treatment doesn't do much for that, but dementia can progress in ways where there can be new behavioral disturbances that might respond to antipsychotic medications. So we could, I'm not going to TDO someone because they have dementia, but if someone presents today, August 25th, with dementia and new behavioral disturbances that may benefit from treatment, they might meet criteria. So there are some diagnoses, and like we said, with substance abuse. Those are tricky. We need to look at what is the risk and how is that manifesting, and how is that connecting back to either previously documented diagnoses or potential new diagnoses that would meet criteria. So we don't TDO because of autism, but we have TDO folks with autism.
Great point. And I would say for the magistrate's office, and we've had some great training from Region 10 and Kurt and Lori and stuff, baseline is what we're looking at. So like autism, dementia, like it's sort of dementia, we see that a lot. Is this their baseline? Are they always aggressive? Did they, and that's their normal, their baseline? Or is their baseline, there's like, oh no, sweet Jane Doe, she was friends with everybody, and then all of a sudden she, started fighting the other residents. So what else is going on? But exactly what Kurt said. Someone asks, how would someone exit this process after the TDO was issued?
Yeah, we'll get We'll get to that. Actually, yesterday I added a specific point because that's happening a little bit more frequent. It used to be a very, very rare occurrence. It's still fairly rare, but it's happening more. So we'll get to that.
Would running up excessive credit card debt, say greater than, be a risk of harm? Could be, could not be.
Yeah.
We really need to know the facts surrounding that, or at least in the magistrate's office. Like we'd be asking a lot of questions. Like, is this just a bad decision, or is this due to mental illness? Yeah. And we'd probably be asking a lot about their history. Have they done this before? What were the circumstances? Were they in a manic episode at the time they did this before? I could just, it depends.
Yeah, that's right. I mean, I gave that example of Vegas, but so there's not like a set number. It's more, is the person going to incur significant financial harm due to their mental illness? Well, what does that mean? As Avnel says, it depends on the facts of the moment and the facts of the case, right? So it's just to say that harm isn't specifically suicide or homicide. There are other ways that someone can incur harm that would meet criteria, but the facts always are going to depend.
When someone is delusional or acting abnormal due to drug use, PCP, MDMA, et cetera, how should that be handled? Well, let's say first, and we forgot to give our disclaimer in the beginning, we can't give legal advice, but we can give
clinical advice.
Yeah.
She can't give legal advice. I can't give clinical.
But we can give information. So we can't say how that should be handled. That will be up to whoever thinks that there's an issue. The methods that you could use are, you could come to the magistrate's office and petition for an ECO, and we would determine whether or not criteria is met. You could call Region 10 to say, see if there's any information that, they're under HIPAA and stuff, but call Region 10 to see, okay, well, maybe they can come in for walk-in hours or bring them to the hospital, maybe they go to the hospital, maybe you need to call their primary care. But you would have to decide how you should handle it, but the options available, at least for involuntary detention, are what we're going on now. And someone acting delusional or abnormal due to drug use could, or again, it all depends on the facts that surround the circumstance and the scenario on whether or not an ECO or a TDO would be issued. I don't think there's any scenario where we say automatically that's going to be issued or that's,
That's right.
So it all depends. And I know that's not part of the answer.
No, but the one thing, substance use is really hard. And in some ways kind of similar to the dementia example a second ago, forgetting the civil commitment process, just thinking about effective treatment for substance abuse recovery. Involuntary admission to a psychiatric hospital typically doesn't do much for substance abuse recovery. Like, there are better methods for substance abuse recovery. Forcing someone to go to UVA 5 East for 72 hours is not that likely to have a positive impact on that person's arc of recovery. So that's the first thing. But the other thing I'm thinking about with a case like this is that third criteria, again, they're not sequential. I think of it as third, need for hospitalization or treatment. If I'm high on PCP and I'm delusional, going to the hospital isn't going to remedy that. Time is going to remedy that. So the person may not meet criteria, not because there's no risk, but because the risk is going to be mitigated in 6 or 8 hours, right? Or it's likely to be, right? Now, again, as Avnel said, there might be all kinds of other information that needs to be factored into how I'm conceptualizing that case. But delusional due to being high is that's a tricky one. And to be frank, it's a really tricky when they're on an ECO, because sometimes it's like, well, if I had 12 hours, we could do some more labs and check how this person's doing when the PCP starts to wane. But they're on an ECO and it's running out in 6 hours. I'm kind of cornered, which gets to the next question about TDOs not having facility. We will definitely get to that. So we're gonna pin that one, because we could. We'll get there.
I'm going to interrupt and just it's at the 10 o'clock hour, so we have 2 hours, and I just want to make sure we respect that time. I also want to make sure that all the questions that have been asked will be answered specifically, and it sounds like you are on that with the agenda of your presentation. Just a reminder to everybody, if you haven't already, put your name and organization that you represent into the chat box. Yes, this presentation is being recorded. And yes, if you would like to get a copy of this PowerPoint, this presentation, send me a separate email to my work email address, which is in the chat box, to get a copy of that. And if you ask a question, we see the name, but we might not recognize who that's coming from. And so just as a reminder, put your name and organization in the chat box with your specific questions. And so we make sure that that is being addressed. So thank you. Let's keep it going.
Oh, I'm so bad at this. Just on the substance abuse, we get a lot, and just because we see it a lot, and I know I've talked to actually some of you about it, like the alcohol-related substance abuse. So we'll get a petition for this person's an alcoholic, and they might drive, so they need to be ECO. Again, that third criteria, need for hospitalization or treatment, is for the mental illness or the substance use too. So one, they may drive is very far removed. Oh, I took away their keys because they were about to drive, may get you a little closer, but doesn't mean that ECO criteria is met then either, because again, they're drunk now because we're looking at the mental illness for need for hospitalization or treatment, not we're just trying to stop them from driving because it's going to be a harm. So yeah, there's substance abuse, which is considered a mental illness. There could be a harm to others or to that person, but again, all four criteria have to be met. What is the need for hospitalization or treatment for that alcoholism? And that may not be there for that moment,
But on those I asked, like, all right, 72 hours, 95% sure he's not going to meet commitment criteria. The judge is going to let him go. And he's probably going to go home and drink and drive then. So like, is hospitalization or treatment going to specifically fix this risk? Or is it just kicking the can down the road? Exactly. Now, again, that's not to say that he would or wouldn't meet criteria. Those are just the questions that we ask in those sort of trickier scenarios. But
I see more. We'll get to the next question set, because a lot of the questions now being asked are in this segment. So how do you petition for an ECO or a TDO? So for both an ECO and a TDO, you can initiate, for an ECO, there's the magistrate route. We call it a paper ECO. It has to be a sworn petition. You cannot call over the phone and say, hey, I want an ECO, and the magistrate's going to issue. Now, the magistrate can issue on their own motion. All right, so it's, let's say, a possibility the code allows it. But throughout this whole process, everything we've been speaking of, if I'm sitting at the desk, I have never seen the person that's being presented in front of me. And over the phone, I don't know, let's say, who you are over the phone either. So you're going to need to come in and fill out a sworn petition, provide a notarized petition, or get to a Polycom video, which meets the Supreme Court specifications per the code, to provide sworn testimony. And that's what we're looking for, is sworn testimony, because we swear everybody in, and you're under the penalty of perjury. So again, we're looking for any responsible person who's under oath. So if you call me over the phone, I'm going to say you're going to need to come in, or you're going to need to get in front of the Polycom video, or send me the sworn. None of the magistrates will issue a sworn ECO for somebody over the phone, other than maybe a certified pre-screener. And we'll talk about why that is in a moment. And it's not a necessity. That's because of, we'll get into that. Yeah. So please, if the law enforcement's on the line, or if you're sending somebody to the magistrate's office, don't tell them that they can call, send them to the magistrate's office to petition for an ECO. Probation pretrial officers, you can petition for an ECO. Corrections officers, anybody working at the jail, you can petition for an ECO. Any responsible person. Now, we will determine who's responsible, but it's any responsible person. This also includes, it says responsible person. 17-year-old daughter who knows that mom's in a mental health crisis and maybe meet the criteria can petition for an ECO. There's no disqualification because of age. Now, an 8-year-old coming to the office, I don't know if I'm really consider that person a responsible person, but really, in a lot of cases, who's going to know better than 16 or 17-year-old teenager who's living with mom or dad? So because they are a minor does not automatically exclude them from being a responsible person. For a TDO, a magistrate is the only authority that can issue a TDO. And again, it's responsible, it's a sworn petition or the magistrate's own motion. So we do issue on our own motion more in these cases because we issue for the certified pre-screeners. Kurt has to provide me with a list. Every time that list changes, somebody is deleted, somebody is added. And that list by code, there, as he was talking about earlier, they are trained clinically and legally in the criteria. And I have that list every time it changes. I just got one this morning. So I know who's on that list. We interact with them on a daily, multiple times a day basis. So a magistrate would feel, it's the magistrate's decision on whether or not they're going to issue on their own motion. There is no mandate for a magistrate to issue on their own motion. So that could change for CSB if they order a certified pre-screener, if we found, because I might get a magistrate who says everybody needs a sworn petition because they need to be under oath. Fine, that's their right. But they do have a polycon video at the hospital and typically do provide sworn testimony. But if you hear, it's like, well, how come Kurt was able to get it, but I wasn't able to get it? That may be the reason why. And it's mostly for the TDOs because they're doing the evaluation. They're the ones that are at the hospital. But anybody can, sorry, I know. No, anyone can petition for a TDO as well. Any responsible person. It doesn't have to be CSB to petition for a TDO, but we do have to have that evaluation. So that is why it ends up being CSB mostly.
Yeah, well, and I think that makes me think of another point that's really important in the petitioning ECO or TDO is so there have been times where, and I see a lot of my Region 10 colleagues on here, folks may call ES either from within the agency or from outside the agency and say, hey, I'm with this consumer and he's suicidal, can you get an ECO? And almost always, not 100% of the time, always is a bad word in these worlds, but almost always the answer is no, because we don't have firsthand knowledge. Now we can help, we can consult, we can call the magistrate and get background information, and they know us and we can review the chart and be like, this sounds serious, but we won't petition unless we have firsthand knowledge. And that's often our recommendation to other folks. It's like, if somebody told you, you got to get to somebody to go to the magistrate. You shouldn't be the one. And that's one of the reasons that they will take it from us often on the phone, because they know the rigor and the ethics that we apply to it, that we're not going to petition based on hearsay. Even if that hearsay is rock solid and we are really concerned about the person, it's not appropriate for us to petition if we don't have firsthand knowledge. So likewise, I think out there in the community, and I know that's been my experience, the times that we have tried that because of whatever reason we make a clinical decision, yeah, I'm going to call the magistrate. Often Abner will say, have you talked to the person? No. And she'll say, sorry, Kurt, I can't do it. And I'll say, okay, like I get it, right? So it's really important not just that we can have a lot of fear and concern about folks, and we have to follow this process rigorously. And sometimes it's really hard. Sometimes it's really, really hard. But so yeah, we'll get into again. My team call us and say, can you call the magistrate? And then they'll give you an ECO. If you call, I'm probably going to say no, but I'll help you figure out the way to do it. And so.
And it might not always, if that happens, I might say to Kurt, like, well, no, even though I might issue if he had the firsthand knowledge, or I might even say, well, know what, Kurt, this is a sticky situation. I'm going to need you to get in front of the video and give me a sworn petition. Again, it's not a mandate or anything that we do. It's the relationship. So, hold on. G is from the jail is on here. I might do one for Miss Murray Key because I work with her so closely and I know her, and because I'm putting my name on it. So just to bring some context to it. and she works for the jail. She's not part of Region 10. Maybe, probably not, but maybe, just to put it in there, or Tom, or somebody that I've worked with very closely and has worked with me very closely, to where I feel comfortable putting my name on it as Avnell Coates says that this information is true and accurate. So that's what the magistrate, we're not trying to be, difficult, or we're just not trying to issue any ECOs or TDOs. There's a level of responsibility and accountability that comes with these processes. So just like somebody needs help, we have to consider that, but we also have to make sure that all of the legal processes and protections are being followed as well. And that person who's petitioning is under oath and has some accountability for the information that they're giving. The doctors at UVA are the biggest example. They have to fill out the petition. They need to have that accountability for the process. Oh, go back. Totally didn't go.
Oh yeah, right.
So the other way to get an ECO outside of the magistrate is an officer-initiated ECO. Per the code at 37.2808G, law enforcement officers have independent authority based on his, and I put in, or her observation or the reliable reports of others. If they find probable cause, they can ECO somebody right there in the moment. That is the officer's discretion, has nothing to do with the magistrate's office. If an officer initiates, they don't have to get any paperwork from the magistrate. They don't have to check it, get a concurrence from us or anything. No paperwork is generated. They go straight to the hospital, notify ES emergency services that they have it, and go on the way. The code allows for officers to issue based off of their own observations or the reliable reports of others. So just like we're looking at a responsible person, they can determine if there's a reliable report that they're receiving that they feel comfortable to find probable cause to officer initiate an ECO. Criteria is the same. The same criteria that we spend the hour going over is the same criteria for officers as it is for the magistrates or CSB when they're doing evaluations, or the special justice for commitment criteria. So timeframes, an ECO is good for up to 8 hours. There's two.
Well, I was trying to think. We were working on these slides yesterday, and I was trying to think of a way to put it in here, and I couldn't quite get it. So I'm just going to say it. And I mean, some of you, because of your roles, will understand these verbs. Others may not. And so I think it's really important to understand that there's two verbs here. There's issued and there's served, or executed. Sometimes served, executed, or interchangeable. Mm-hmm. And so timeframes matter at both of those. So there's a time frame for an issued ECO that's not yet served, and then there's a time frame once that ECO is served. Same with the issued TDO and served. So as we're talking through this, just kind of keep in your mind, like we're talking about two different phases of these orders, right? Like once it comes off her printer, it's issued. Once a law enforcement officer takes it to the person and says, "Hey, Jane Doe, here's this piece of paper, sign, it is now served." So just I think that's sometimes that's misunderstood structure. So
8 hours after issuance to serve there for ECO. So I printed off of my printer at 10 o'clock. There's 8 hours to find that person, to serve that person. Once the person is served, there's another 8 hours for the evaluation and everything before it expires. Evaluation, bed search, or determining that the person's going to be released. 8 hours. After the end of that 8 hours, it is expired. There's one exception for the whole no TDO recommendation thing. If CSB recommends no TDO, there's like an appeal process to the magistrate. That person is to remain in custody per the code, specifically in the code, until that process is completed. But
of course, it doesn't say by who or on what authority. It just says remain
that person is to remain in custody.
Details.
But 8 hours, once that 8 hours, so the ECO can expire when a TDO is issued. So that could be, I could issue a TDO at hour 6, the ECO is over, issued. The person is not found to meet criteria, ECO expires. They said they don't meet the criteria, we're releasing them. That could happen before. So let me say up to 8 hours, or the 8 hours expires. So at 8 hours and 1 second, it's done. A TDO is good. There's 24 hours after issuance to execute or serve the process. And then once served is good for up to 72 hours. If we cannot extend an ECO or a TDO, and we cannot issue a new one based off of the same facts. So if an ECO runs out at hour 8 and 15 minutes, and it's like, oh, well, this person's, still in crisis, it's still hard, all the criteria is still met, we cannot issue a new ECO. They are free to go. Or we cannot issue a new process. Same with the TDO. We cannot say, okay, well, we'll give you another 2 hours to do the bed search. 8 hours is done, 72 hours is done. We can't issue another one based off of the same facts.
We said versions of the same thing, but to point out again, like when we're saying things like we can or can't do, it's not because that's what we want the process to be. It's what the process is per the code, right? So there may be times where I'd say, man, I wish you could extend this 2 hours. And she would probably say, yeah, I sure wish I could, but you can't, right? So then what? That's what some of the questions are already. Like, so then what? Well, we'll get into some of the then what's. To point out another, I'm going to get in the weeds for 90 seconds, but just to point out how difficult, there's so many places where this gets difficult, because again, at the core of this, what we're trying to do is serve my friend Jane Doe, right? That's really what this is all about, is to make sure Jane Doe is safe and gets the treatment that she deserves. But we have to follow the code. So as Avnel said, maybe you heard this detail, the ECO is over when the TDO is issued. Now remember, I said those two verbs, issued and served. Jane Doe, once the TDO is issued, is no longer in legal custody. But Avnel's office is across town. The printer for her computer that prints out the TDO is not next to Jane Doe's bed. So even if it was the perfect of circumstances, and it was great, and Jane Doe is going to stay at UVA and go up to UVA 5 East, so she's in bed 201 in the emergency room. She's going to go to 5 East. It's only 4 floors away. No big deal. She's not in lawful custody from the moment that piece of paper prints at Avnel's office until some law enforcement officer picks it up, drives across town, comes into the emergency room, finds Jane Doe, and signs a piece of paper. So that's in a perfect situation. What if the law enforcement officer is from Louisa County and is woken up out of bed because it's 3 a.m. and they're coming from overtime and they got to drive an hour and a half in? Jane Doe's not in custody for those couple of hours while that piece of paper is sitting on the magistrate's printer. That's always been the case. The code has never reconciled that problem. I can't think of any situation where we go from ECO to TDO where there's not a gap in custody of at least a few minutes, if not many, many hours. Then what?
Even if the paperwork is printed at the hospital where the person, Jane Doe is, it's still a gap.
Yeah, even if it's a few seconds, it's a gap. So what do we do about that, right? And what we do is we have good partnerships and good communication, and we solve problems. But it's just to point out that we'll get into some other things with the bed census crisis and the problems that's creating. The code is not built in a way to be nimble or to recognize these little kinks that can create significant problems when there's pressures on the system. So just pointing one of those pressures out. Somebody asked earlier about how someone might come off a TDO before a hearing. Now that doesn't happen often. That is in the code. There is a provision, if I'm going to get the language right, it's the facility director upon the recommendation of the treating psychiatrist that the person no longer meets commitment criteria. So Avnel issues a TDO based on my testimony. It's served on Jane Doe, and the next morning, some new factor comes to light. There's no hearing that day. It's Saturday afternoon, but the treating psychiatrist can call the facility director. Now, who is that? Depends. What if they don't have a facility director? Each facility has to determine how they interpret that language in the code. Ultimately, they're taking the liability. So it's not the special justice, it's not me, it's not Avnel, it's that treating psychiatrist and facility director. So historically, they've been pretty hesitant to do that, facilities, because that's a lot of liability to take on. They'd rather wait a day and have the special justice run the hearing. But what's happening more now is with extended bed search processes and some of the things that we'll get into perhaps, or some things you know about, it is becoming more appropriate for folks to be released prior to a hearing. And so I'm grateful that UVA, again, historically has been very hesitant to do it, understandably, has shifted that paradigm a little bit and has been releasing more folks. The treating psychiatrist, typically the psychiatric consult service will call their administrator and say, hey, will you sign off on letting us discharge Jane Doe? When they do that, we'll weigh in as good consultants and partners, but that's not our decision, because at that point, legally and procedurally, that Jane Doe is a patient of their hospital. So I have no authority and no role to say, yeah, you should release her, or no, you shouldn't release her. We weigh in, we're involved, we have a stake in it from a clinical standpoint, but not from a legal or procedural standpoint. So a facility can do that, but I can't make it happen. She can't make it happen. Only the hospital, the treating facility can determine if they want to do that.
Just for law enforcement, if you have an ECO or a TDO that's not served or that is unexecuted, you can return it back to the magistrate's office or to the court, and we'll mark it, or you'll mark it as unexecuted, and we'll turn it into the court, or you can turn it into the court directly. Transportation. All right, so this is my law enforcement partners, and for talking about alternate transport to here. So transportation rules for ECOs and TDOs are different. For an ECO, it is all about where the person is currently located. So if the person is from Charlottesville, but in Virginia Beach, they're in Virginia Beach. For an ECO, the designated transport will be the primary law enforcement agency for the area where the person is currently located. Now, there is some language about if the CSB serves one or serves multiple jurisdictions, but it all comes down to where they're located. Now, unless law enforcement, if Norfolk took the person in custody, even though they were in Virginia Beach, Norfolk would be responsible if they got an ECO, but then they're probably officer initiating. But it's where they are located for an ECO. So if somebody lives in the city, but is at the jail in Albemarle County and has a mental health crisis, Albemarle County Police Department is going to be designated as the primary, as the law enforcement agency for transport, because the person is located in Albemarle County. Once we make that designation, that's the designation. Somebody could be at the Wegmans down by our office and be at 10:24 a.m. and 1 second in the county, and then at 2 seconds we'll be in the city. We're not going to keep going back and forth and changing the designation. It's where the last known where their last known location where the crisis was occurring is the designation. The Virginia Code specifically allows for ECO or TDO to be executed anywhere in the for a law enforcement officer to execute an ECO or TDO anywhere in the Commonwealth. So once we make that initial designation based on the facts of where the crisis was occurring, it won't change because the person's location has changed, which happens a lot because people were mobile, were transit, right? Somebody could have been in Nelson and as a part of their crisis, leave, take off, drive off, and we don't even know where they're at. Nelson would still be the designated transportation agency because that's where the last known occurrence is. They might have said, oh, well, they ended up in Waynesboro at a friend's house. It's not going to be changed because that's where because the person has moved. Transportation for a TDO is based off of the person's residence. So where does the person live, or where do they maintain residence? So the person who lives in the city and is in the county and all this stuff happens, and say they're in the part of the hospital that's in the county where their evaluation takes place, and that's where the TDO is issued, they live in the city. The city is still going to be responsible for their transport. Now, there is an exception. It's the 50-mile rule.
Mm-hmm.
So
this is my second favorite part of the presentation.
So if the respondent, and I say respondent because that's how it's referred to in our office, if the respondent is more than 50 miles away from their residence when they are TDO, more than 50 miles, the primary law enforcement agency for where they are located then becomes responsible for transport. So in this example, this is going to be less than 50 miles. A resident of Fauquier County is transported on a TDO from UVA Hospital in the city of Charlottesville. So they live in Fauquier, but they are in the city of Charlottesville. That's not right. I'm sorry. Yeah, my lines are. And I've done this. It's 46.04 miles away from the closest boundary of Fauquier County to the city of Charlottesville. So sorry, guys. I was playing around with some examples. So they would be, Fauquier has to drive out to the city of Charlottesville, Fauquier Sheriff's Office, out to city of Charlottesville, pick that person up, and then take them to the bed location that's been designated by the CSB. Because they are 50 miles or less away from the city of Charlottesville. No, this one's right. This one, a resident of the city of Richmond needs to be transported on a TDO from UVA Hospital in the city of Charlottesville. The city of Richmond, the closest boundary of the city of Richmond to the city of Charlottesville is 57 miles away. So the city of Charlottesville is going to be responsible for that person's transport. I don't know, again, like Kurt said, these are all legality. This is all in the Code of Virginia. We don't have any say over what the rules are, and we just have to follow the rules. So trust me, I don't come in and say, oh, today is the city of Charlottesville's day and all TDOs and ETOs are going to be for them. It's what comes into our office and what the rules say. I don't know how 50 miles was the chosen designation, but it is. And that's how we make our transportation designations. So alternate transportation providers. So the code, I guess the kind of the mandated, and it doesn't say mandated in there, but transportation is done by law enforcement, shall be done by the primary law enforcement office agency for where they live or where they're located, depending on the ECO or TDO. But then an alternative is an alternative transportation provider. And that's if that, we call it ATP. We have a whole bunch of 3-letter acronyms in our world. We call it an ATP, but they have to meet certain criteria. They have to be willing, able to transport safely, and available. So if an ATP can be anybody. It can be grandma, it can be mom, it can be a private ambulance company, it can be G4S, which we're going to talk about, is the state contracted ATP agency, but all must meet this criteria to be, and then, and only then can we take the designation away from law enforcement. Available means they are available now to come and do the transport. Willing, they have to say yes, they have to agree to it, and able to transport safely. That's where we get hung up a lot of times is, well, if I just issued a TDO for someone who's suicidal because they're trying to cut their wrists and they just had stitches and they're picking out their stitches because they're still trying to kill themselves, is there going to be somebody who's able to transport safely, or an ATP? I'm going to probably say no. G4S is the state contracted ATP agency. So their ATPs still have to meet the same criteria, but we've met the G4S delegation throughout the years. They have different hubs. They have a whole system set up throughout the state to provide these transports. Now they have qualifications on who they will and will not transport. And then they have to be able to respond within 2 hours, because that's the state contracted period within 90% of the time. But we use a 2 hour. Anybody else, it's going to be immediately. But since they have a contract with the state, they have up to 2 hours to respond. But they still have to meet the same criteria. And the magistrate still has to approve for them to handle a transport.
Yeah, we got a lot of questions. All right. So this is a question time. Where's the chat box? There we go. Okay.
Before you get into the questions and answers, for anybody that didn't feel like their question got answered in the previous part, if you do me a favor and copy that and then drop it back down into the chat box, just to make sure that we're respecting your questions and your concerns. And also just to let you know, we have about 80 people in the room from schools, law enforcement, sheriff deputies, police departments, probation, parole, OAR, mental health advocates, the whole 9 yards. So everybody has their specific and, to be honest with you, selfish perspective of the concerns that you have with this process. And we want to make sure we're addressing that. And so again, please put your questions in the chat box and make sure you put your name and agency within that so we can be addressed. So Kurt and Evnell.
All right, so Ms. McKinnon, hi, Ms. McKinnon. I would see your question about why do you have to have a jail officer to petition for an inmate TDO, because inmate TDOs have totally different criteria and initiation process. So we have that on the agenda to go over as well. But it does not, TDO for an inmate, somebody who's in custody, is different than the process, the adult ECO TDO process that we're discussing now.
And there's still this question, I think it was from last time, but TDOs being issued to facilities that are not accepting the person while another bed is being located. We'll get to that. We'll get to that in a little bit. And I think it answer that sufficiently. Mm-hmm. And then there's this question: what determines law enforcement transport versus medical transport to TDO location? I think we probably both have an answer to that. I mean, but
well, all right. And we should have said this too in the beginning. So when we talk about ECO TDO, there's mental health ECO, mental health TDO, medical ECO, medical TDO, and all four are different. And then for mental health, there's mental health adult ECO, mental health adult TDO, then change adult to minor. Then we have the inmate. So there's several different processes when you're talking about ECOs and when we just say ECO TDOs, we really should be like specifying which ones that we're talking about.
The code frustratingly just uses ECO TDO for the behavioral health ones, mm-hmm. but does say medical ECO TDO for the medical ones. Mm-hmm. And so there's not it's just kind of confusing.
So when there's a medical transport to a TDO location, there's no, at least I'll talk from my world, there's no designation between a medical transport. I'm not sure, I might be missing the question of what we mean a medical transport.
I think
okay.
Yeah, I mean, Melanie, let us know if this hits your question, but there is a scenario often where it's not always somebody that's older, but let's go with an older adult who, they're medically compromised, and it would be better for them to be transported by an ambulance to the TDO facility than law enforcement, right? They need a stretcher, or they're infirm in some way. What determines whether or not they go by law enforcement or by ambulance? The thing is, again, the code doesn't say anything about G4S. It doesn't say anything about ambulance. It doesn't say anything about grandma. It doesn't say anything about me. It doesn't say anything about you. It just says alternate transport provider. So for Avnell and I, from a legal standpoint, there is no difference between an ambulance, G4S, or grandma as a potential alternate transport provider. So there's no preference for it. If somebody might clinically, medically need an ambulance, they still may not meet the criteria for alternate transport provider. And so we run into that a lot. We've had times where law enforcement will show up and say, I can't drive this person. And I'll say, I won't say this exactly, but I'll say something to the effect of like, I know you can't, but you gotta, because I'm not able to get an alternate transport order for this person. Sometimes we can, sometimes we can't. Maybe there's an ambulance company that's maybe that none are available, or maybe they aren't willing because they have certain things that they want in place that we can't put in place. Or maybe the person's behavior, despite their medical needs, is so dangerous that I put them in an ambulance and I'm going to drive them. I'm not sure. I get an order from them that puts them in an ambulance, and they're going to drive 2 hours away where they're going to be ripping lines off the wall and kicking out the back window. That's not safe. So it might be that medical transport is what would be medically indicated and clinically indicated, but may not be legally possible. And so we run into that a lot where we don't even petition them for an ambulance because we can't.
And we've had times where we've been petitioned for an ambulance, and it makes sense that the person should be in an ambulance for whatever reason, but they don't meet the criteria. They're not safe to transport in an ambulance, or the ambulance is not willing. Medical condition is not a consideration for an ATP, like a mandated criteria. It's available, willing, able to transport safely, regardless of anything else. So
yeah,
that's
right.
Yeah.
And then Jeremy, so your question about, when CSB is making a decision on ATP, can law enforcement get consultation on ATP prior? I think two things on that. One,
the first one, from our point of view, we are G4S or ATP. So an ATP generally, by the time law enforcement even, and Kirk can talk to this, law enforcement would even know that maybe possibly in a lot of situations that there's going to be a TDO, it's too late. The process has already happened. And then specifically for G4S, they're willing on the request of CSB. So everybody can't call G4S to request.
Right, that's right. That's within the contract.
The contract.
Yeah, and the other thing is so there's two things. Actually there's sort of three layers, I guess. We got to feel comfortable requesting it. We have to call G4S and make sure they're comfortable with the transport and have a truck that's available and a driver that's available. And then we petition them, and they got to decide whether or not they issue the order. So whether or not someone is transported by ATP isn't solely the pre-screener's decision. There's these three different decision points. And I'll just go through our process. When we are doing an initial assessment, we have a few different documents that we complete. We have a pre-screen that we've talked about, but we have some internal documentation that we do. And in one of those is a box, because often I'll start a case, but then my shift will end before it's over and I hand it off to Rebecca or Chris or whomever. I will mark a box in there. I think Jane Doe is or is not appropriate for alternate transport for these reasons. Now that might change between I go off shift at midnight and the TDO happens at 4. Maybe something new has happened that she's calmed down or escalated, and it's new environment. But we're trying to think about that throughout the process as to whether or not G4S can be possible. So I don't know. I hope and think that we are consulting with law enforcement, but also, to be frank, our decision isn't based on law enforcement resources. It's based upon what's clinically appropriate for the individual. Understanding that the more often we use ATP, the more often we use G4S, the better it is for law enforcement and the better it is for the person. So we don't want to not use it. We want to use it as much as we possibly can for all of the benefits. But our decision is based upon their presentation and what is appropriate and safe for the person in crisis.
I'll just add on to that. So ultimately, it's the magistrate's decision on whether or not an ATP is issued. And just to echo, what our decision is based on is the ATP willing, available, and able to transport safely, based off of the information from the petitioner that we're getting. So again, we understand all of the circumstances that are going with the state hospitals, staffing in all departments. But we can't use that as, well, we are, whichever law enforcement office agency is not available today or right now, or they don't have the staffing, so we're going to issue ATP. We can't, legally, we can't do that.
Yeah. Renee, see your question about ECO TDO types. I think we will clarify that because everything we've talked about so far are adults.
Mental health.
Adult mental health. And so we're going to talk in a second about children, and then we'll talk a little bit about medical. So I think we will, and special populations like inmates and others. So just know that so far it's all adult mental health, civil, and we will get into the other ones in a second. And Jeremy, we don't have good stats on how often ATP is used. It's being used more. I mean, we have decent stats, but it's hard to really get for a number of different reasons. The state's expectation is 50% of all TDOs statewide would be transported by G4S. To be frank, I think that's an ambitious and not sure if or when we'll get to that, but it's getting more. We've been using it more here locally. I don't have a percent.
I can just say, obviously they are issued. I've issued personally. I know magistrates issue, and we do deny. So, but I don't have any numbers on, from what's requested, like percentages either.
All right, let's, again, there's not to shortchange those questions, but now an hour and 40 minutes in. All right, so kids, main key differences.
So the differences with, so now we're talking about mental health, ECOs and TDOs for minors. So the differences, and if we don't talk about the differences, then it's the same as the adult, but the way that it's initiated is different. So for minors, the sworn petition can be from the treating physician or the parent. Now, if the parent is not available, unable, or unwilling, then a responsible adult can petition. So this plays out a lot with the TDO. So I said a lot of times the pre-screener is the one who petitions for the TDO, but if it's for a minor, we need information on why it's not the parent, because the pre-screener is a responsible adult or responsible person. There's not a specific carve out for a pre-screener. So they would provide us like, oh, well, mom's on 95 in Northern Virginia and won't be here for 7 hours, unable. I'll say it's not too hard to get over this, hurdle, but the code still requires, they give the treating physician and the parent like absolute authority to petition, and then give a responsible adult kind of contingent authority to petition if the parent is available, unable, or unwilling.
There still needs to be a CSB evaluation.
Yes.
So it's not that we aren't part of completely cut out of the process. It just means the petition should be initiated by one of those other entities if possible.
Because remember, anybody can petition for a TDO. It just happens to be pre-screeners most of the time because we're following that continuum. There's another difference is the definition of mental illness. So we had the autism spectrum question earlier. If you look at the code for minors at the bottom and it's bolded, intellectual disabilities, head injuries, learning disability, or seizure disorder is not sufficient in itself to justify a finding of mental illness within the meaning of this article. So as we discussed, we got into it a little earlier. One of these diagnoses by itself is not enough, but maybe there's something else going on that gets us to something else. We're out of that baseline. We're out of what they're normally, the spectrum of their learning disability.
Into this age appropriate.
Right. Yeah. So, that kind of going passive harm. So by itself, and that's only for minors. Those are exclusions for definition of mental illness for minors. That does not apply to adults. Consent. So remember, there was 4 criteria we went over for adults. There's only 3 for minors, 3.5. Feel better?
We'll explain that. There's no unwilling or unable consent criteria like that. That's specifically defined in the code for adults. It's a compulsory treatment is required. So they take out the word consent word, but I'll let Kurt go into those. But we're not asking like, what are they unwilling or unable for
children or for minors when the magistrate is considering.
The code has the mental illness, the risk of harm, and need for treatment, but it doesn't say unwilling or unable. And you know, when we are having a drink on the weekend and thinking through like, well, why is that? To be honest, I'm not sure. My theory is that minors can't consent anyway, right? They're under 18. They by definition, they can't consent. The code does have the language, they must require compulsory treatment. So what I take that to mean when I'm doing an assessment, if a kid says, yeah, I'll go to the hospital, and mom says, yeah, I'll go to the hospital, while the code might allow me to petition for a TDO if there's mental illness and risk of harm and need for treatment, it would be inappropriate and unethical for me to do that if they're willing to go and legally and appropriately can admit themselves. The compulsory treatment is what I see as that fourth criteria of unwilling, right? If it's such that if they didn't want to go, they would have to go because of the risk level, that to me is what compulsory treatment means. So it doesn't have consent, which frankly sometimes can be it's helpful, but it's not that we don't consider consent. It would be inappropriate to TDO someone who is willing and able to admit themselves regardless of their age.
And the next difference is the passive harm. So remember, we talked about harm and we talked about active harm and passive harm. Passive harm is different for minors. We're looking at, is the minor experiencing a serious deterioration of ability to care for himself in a developmentally age-appropriate manner? So a 6-year-old who's saying that they're not going to take a bath, that's what 6-year-olds do, right? Whereas a 17-year-old, we might be more concerned. Maybe they don't either, but we're looking at age development with their others in their age range, kind of the objective view of category of 6-year-olds in general. Is this out of the norm for passive harm? So that inability to care for oneself, provide for own human basic needs, you know, because if you think about it, a 6-year-old who's providing for their own basic needs, typically their parents. So, well, how do 6-year-olds provide for their own basic human needs and protect themselves? And we're not going to compare a 17-year-old to a 6-year-old. We're looking at them in their age range.
And I think that's, Anna Mendez asked a question before about autism spectrum. Like that's where this comes in. You know, if a 16-year-old who is, you know, has significant behavioral disturbances and is threatening family or you know, breaking windows or whatnot, maybe there's autism, maybe they're not. But I'm probably going to go to this point of like, that behavior is not developmentally appropriate, age appropriate, and is creating significant risk. And so I can go to this place within the criteria to find the justification of petition for a TDO, not based on a diagnosis of autism or a diagnosis of intellectual disability, but that the child is not behaving in a developmentally appropriate way for their age and abilities.
So another thing for minors, and we're going to talk about this when we get into the inmate stuff, for what the rule is for adults. But so the general rule for adults is an adult in custody, we cannot issue an ECO or TDO. But for a minor, we can. So a minor who is in a detention center, shelter care, we can issue an ECO or TDO for them when they're in custody, like you said, government custody.
So there's a big difference between minors and adults on mental health ECOs when they get, well, I guess that last little one for kids who are admitted. So questions before I talk about my team. Let's see. How often is ATP used? We got that one. We got names. Oh, no new questions.
No new question. Okay.
Any new questions?
About minors?
Sweet.
All right.
We'll keep rolling. We can always double back if something pops up. So now this is a slight detour. We usually talk about my team at the end, but we thought it made sense for a few different reasons to move it up. So I'm going to just kind of give an overview of what Region 10 Emergency Service, who we are, what we do, and then get into some of the stuff, some of the shit that we're all in right now, because that's not really like the code drives it all, but we're going to detour from the code and talk about actual real life on the ground practice for a few minutes that I think will answer some of the questions. And then we'll get back to some of those special populations and stuff. But so the team that I'm privileged to run, we have 19 and a half full-time staff, myself and 2 program managers, Chris Barnes, I think some of you know, and Caitlin Powell, who just was promoted to be a program manager. So the 3 of us administrate the team. We have 12 and a half full-time certified pre-screeners. We have one woman who's 0.5 salary. 12 and a half full-time pre-screeners. 2 of those positions are open. So I'm down 2 people. So if you know any good clinicians, give me a call. We have 2 support staff that primarily help us with bed searches. We're going to talk about bed searches in a second, but they do a lot of other great stuff. We have one, that shouldn't be an S, one crisis intervention clinician, which is a newer position. We had a version of it a few years ago. It was vacant for a while, and we've just put a wonderful clinician in that spot. And we have 1 full-time peer support specialist. Hope to get back to where we have some part-time peer support specialists as well. We also have a whole bunch of hourly certified pre-screeners. These are folks that work at DSS or private practice or other parts of Region 10, but have gotten certifications of pre-screeners and pick up weekend shifts and whatnot. So we, as I said earlier, the only reason my team exists is that the code says anyone on an ECO must be evaluated by a CSP. So that if everything else goes away, if it's down to Chris and Caitlin and I, the only thing we're going to be doing is ECOs, and all the rest of the stuff is going to go away. But that's not just what we do. So we are mandated to evaluate individuals on an ECO. We also, if you remember back an hour and 52 minutes ago, said that we can evaluate folks not on an ECO. So our local practice, the way we work that out is if UVA psychiatry, if someone is at UVA or Martha Jefferson, because UVA psychiatry does the evaluations there as well. If someone's at either of those hospitals and UVA psychiatry feels that they meet inpatient or TDO criteria, they can't petition for a TDO without an assessment. They'll call us and request an assessment, and we'll go and we'll do one. And I'll talk about the frequency of that in just a second. Since we have to know when there's an ECO, that means we have to answer the phone 24 hours. So that means we answer the phone 24 hours to know about ECOs, but also for anything else. We get every call. I'll tell new clinicians, people call us when they don't know who else to call. So that means we get all kinds of questions, many that not that we can't answer, it's like that aren't ours to answer, but we get all kinds of calls. Generally, they fall into 2 categories. Individuals in crisis or the supporters of people in crisis who need intervention, who need assessment, who need information, who need support, who need something. We also get a lot of consultation calls from you guys, from people you work with, from anyone and everyone else. Some of those are real procedural. We need that piece of paper faxed over here. And some of them are, how do I get an ECO again? And every other kind of call that you can get. When we have enough staff and space and availability, we do outpatient crisis screenings and intervention at our office. I think all of you know that there's efforts to create more crisis intervention options in the community, whether that's co-responders with police or mobile crisis. Those will develop. They may or may not be within emergency services or within Region 10 even, but we are trying and always want to have as much capacity as we can to do outpatient crisis intervention at our office, or at least provide screenings here for folks who may not need to go to the hospital, but we're not quite sure what's going on. We have to constrict that when we don't have enough staff or when we're too busy at the hospital. So it's true that sometimes we have to say no, unfortunately. We also, I have one colleague, Andrew Fry, who 3/4 of his time are put towards managing NGRI, not guilty by reason of insanity, people who have that designation or are on mandatory outpatient treatment orders. We also, as I said earlier, cover civil commitment hearings, folks that are on TDO that get to the hearing phase, and Pam, our peer support specialist. So we have some sort of special side duties, but our main 3 things are some outpatient crisis stuff, answering the phone, and doing evaluations at the hospital. Just to get a sense of those evaluations, right? So I looked at some data for 18 months from January 1st, 2020. We changed some forms, so I was able to get this data more easily on January 1st. So that's why it starts there. Went through June 30th just to get around 18 months, a round number of 18 months. In that time, we did 1,700 evaluations. 884 of those were ECOs. 816 were requests by UVA psychiatry. So those of you in law enforcement or those of you that know about ECOs, you can figure if your friend's on an ECO, we are also doing another evaluation at the same time that's someone who's not on an ECO. It's about 50%. And that number is, the numbers on this slide are remarkably static. Every once in a while, I'm like, there's change. We're releasing more people than we usually do. We're TDOing people more than we usually do. We're getting so many ECOs. These numbers are remarkably static for Region 10, at least. I don't know other places. Well, and again, ECO, I put a little asterisk there. That number, that 884, is both officer initiated and paper ECOs. I will say in the last year or so, there has been a decline in the number of officer initiated ECOs. There's been a commensurate increase in the number of paper ECOs. We could speculate on why. I don't know that it really matters actually that much. I mean, it is what it is, but we have 884 ECOs in that time frame. Again, this is just ridiculously static. Of the people we see, about 2/3 are TDO'd, about 1 out of 5 we release on a safety plan, and another 11% agree to voluntary hospitalization. If I break out the UVA psych requests versus ECOs, there's some slight changes in those percentages, like 1 or 2%. But pretty much 1 out of 5 people we see goes home on a safety plan. 2 out of 3 people we see are TDO'd. You might notice that doesn't add up to 100. There's like a 1.5% of other, like people that are medically admitted because their overdose was so severe and we just back out of the case. I don't pull those in. That's a pretty small number. So that it gives you a sense of what we do, the scale of what we do, and the outcome. And frankly, I think the number that I'm most proud of, I think is the word, is that 20%. That the value we bring to this process is that we are able to, it's not that those folks, again, it's not that there is a mental illness or risk, it's that we're able to find other ways to mitigate the risk, to get them home or into some other environment rather than the hospital. Do I wish that TDO number was lower? Yeah, but I think I also recognize that life is hard and risk is real and crisis is heavy. And when we TDO someone, it's not because it's easy, it's because it's necessary and criteria is met. This slide, I don't want to spend a whole lot of time to it, basically because if you look at from 2017 on, these lines are fairly flat. But it's an interesting slide. You can see there's a lot of change in 2013 to 2015. We hoped that was going to be a blip. It was not. So here we are. You'll notice the total hospitalizations, this blue line. So that's ECOs and the voluntary hospitalizations that we facilitate. That's not all voluntary hospitalizations in Charlottesville. Many of those are done by UVA or Martha Jefferson, and we're not involved at all. This is just the ones that we're involved in. That's decreased a little bit, but the 779, that's the most TDOs we've ever done in a fiscal year, in fiscal year 21. So pretty close to the last 3 years. So I'm not like losing sleep over it being high, but the point is it didn't go down during the pandemic. It went up marginally. This is really where this is the problem. So in 2014, 1/3 of the TDO, this is just TDOs, this isn't voluntary. So you can add numbers to these because we do the same for voluntary as we do for TDOs. In 2014, 1/3 of the TDOs were bed searched. And that represented 149 because as you see, in that year, there was a lot fewer TDOs. So 149 over a year, 365 divided by 149, it means 1 bed search every 2.5 days. Fiscal year 21, 64% of our TDOs required bed searches. That is a number, that comes to a number of 501 TDOs. Now, that's actually the number of TDOs, not the number of bed searches, because most folks require 2, 3, or 4 bed searches. So 2014, we're doing 1 bed search every 2.5 days. Now we're doing 4 bed searches a day. What's a bed surge? That's us calling 32 to 35 hospitals, giving them, I'd say probably an average of 5 or 6 minutes per phone call, sending a packet of information that could be 20 or 30 pages long, waiting an hour or two for their doctor to review it and decide if they want to admit the person, calling us back and saying if they will. It is a laborious and frustrating process that we are doing 4 times a day. And that's a pain in the tail for us. It also means that person in crisis is not being served. It means they're waiting, their parents are getting frustrated, their sister is starting to create havoc in the emergency room because they got to get the heck out of there. It's no good for anyone. It's what we're doing. So we've heard about the bed census crisis. I could spend 3 hours just talking about that, but I was trying to think yesterday, what are the most salient points about the bed census crisis in terms of this presentation? I think it's really important to understand, we know that after Gus Steed's unfortunate death, the code changed such that someone is on an ECO and meets TDO criteria. As I said earlier, I can't call Avnell for a TDO without an accepting facility. That was not the only thing that led to Gus Steed's death, but it was the procedural gap that allowed for that problem to happen, because the pre-screener did assess him to meet criteria, but did not have a willing facility. The ECO expired, he leaves. Okay, how can we fix that? Well, the state can control the state hospitals. So we'll make them admit that a person in that situation. It solves that problem. It has created many, many more problems. But it really comes down to this. Acute psychiatric treatment. Jane Doe on the downtown mall, what she needs in that moment is not Western State. Western State is built to provide long-term treatment, which is a very different treatment model than acute treatment of, let's get you in here, Jane Doe, and put some Band-Aids on, let's make some phone calls, let's do what we need to do to mitigate your risk and get you home. It's a whole different thing. I wish I knew other facets of medicine to give a good analogy, but it's a different treatment modality. We have flipped it now. So now people with acute needs are going to state hospitals, which is not good for the state hospital, and it's not good for the individual. And on the opposite, people are staying at UVA for months. We've had people at UVA since February waiting to go to Western State, not able to go to Western State because Western State doesn't have any beds. So UVA is burning a bed with someone that they're not built to care for 8, 9, 10 months. It's a different treatment modality. So a lot of times people are like, just send them to Western. And I say, no, I will not do that, because despite the census pressure, my objective is to get the person into the best treatment facility, and Western is not the best treatment facility for someone with acute psychiatric needs. So I'm going to do all I can to get that person to Poplar Springs or Pavilion or UVA. And if I can't, then they'll go to Western. So I try really hard to hold on to what's best clinically, even when the system starts to break down. So that's point number 1.
Yeah. I just want to clarify. So when Kurt's talking about the requirements for a TDO, the criteria is the legal requirement. And that's when magistrate is considering whether or not to issue a TDO. If those 4 criteria for an adult or the 3.5 for minors are met, we shall issue. The part about we still procedurally cannot issue a TDO without the bed, but that has been worked into the code now of the state hospital. So there's always a bed.
Right.
Per the code.
Right. So there's always a bed, but what if there isn't? So, all of us, I said, I'm down 2 people, everyone on here, if you are fully staffed, don't say it, because I'm going to come and slash your tires. Everyone is burned out. Everyone's, I went to Panera yesterday and you couldn't go inside because they didn't have enough staff to work the restaurant, right? Like that's not a mental health thing, it's an everywhere thing. So Commonwealth Center has less than 40% staffing. Western State is less than 70% staffing. Meanwhile, they're taking TDOs at a crazy clip. So it's unsafe. Like it's just flat unsafe for the patients and for the staff to bring people in, yet the code says that they must. And it's not just Western, it's not just Commonwealth, it's every hospital, and it's the emergency room, and it's our agencies as well. But the code must be followed. So what do we do if there's no facility that's able to take a TDO? What do we do if it takes longer than the ECO period? We solve problems. And so what is happening regularly is we petition for a TDO to the state facility, which is what the code allows, code requires. We get that TDO, and then we say to law enforcement, we request that you delay transport. And oftentimes they do, because what else can we do? And sometimes they don't. And there's nothing we can do about that. The hope is we get the TDO to Western State because the code allows. It keeps the Jane Doe in lawful custody, not in a good place, not where she needs to be, but at least she's safe. And we continue to try to find a bed somewhere else, and continue to work with Western to get to a place where they have a bed, or if they don't have a bed, find another state facility that does. You all may know recently the Commissioner of the Department of Behavioral Health stopped admissions at many state facilities, including Western State. Understand, and I'll get to the slide in a second, understand, but that didn't solve a problem. It didn't solve a burden, it just shifted it, right? And so it's not, I understand it. If you only got 40% staff and you're at 110% capacity, it is unsafe and inappropriate to bring in more people, but then, right? And so what we do regularly is just solve problems. And we're so grateful for our law enforcement partners and so grateful for UVA Emergency Room. Those two entities and all of them carry the heaviest burden of this problem. But it really is what to do if there's no facility and what to do if the ECO expires or ECO runs out. We run into that daily, which is why we're doing 4 bed searches a day. I put this up, as I said, a little bit, but I use this in a different presentation, but it kind of sort of fits here. The pre-screeners there doing their thing, doing their assessment, as we talked about before, that's our function. But really, once the assessment's done, we move into a more, the bigger part of our role, which is system management, process management, stakeholder management. You got the law enforcement agency that brings the person in on the ECO. You got hospital security, in our case, which is partnered with University Police. It might be a different agency that has to deal with the TDO. Hopefully we can bring in G4S. So now I got 4 different stakeholders that are invested in this process and this outcome. You got the treatment team in the emergency room that's trying to take care of the person, as well as the emergency physician who's managing, traumas down the hall and helicopters coming in and COVID patients. You got the ED social worker who's involved. You got the psych consult team who's involved, invested. And then you got the 32 private hospitals and the multiple state hospitals. And all of them are invested in this process, and all of them come to us. They don't often all talk to each other. So we're having to communicate to all of those different entities that have different motivations, different languages, different timeframes, different leadership, and we do our best. It's also, again, important to point out, if someone's on an ECO, that by definition means they don't want to be there. They don't want our help. And so all of these people, but to that person, are seen as adversaries, right? Like no one here is on their side, even though hopefully all of us are doing our work because we want to serve our community. The person doesn't necessarily feel that. So that's, I always start with that. It's also important to note that I don't have any authority or ability to control the code. All I can do is petition her. I can't make her issue things. I can't tell law enforcement what to do. I can't make Western State admit someone. I can't make UVA draw labs. I can't make, all I can do is consult and ask. So that's a bit of a problem. But then, like I said earlier, all of these entities, all of these providers and agencies are experiencing tremendous and unsustainable burdens right now because of the census pressures and because of the increase in crisis in the community. But reducing them only shifts them to another entity. I don't know, it's the last thing I'll say, and I'll get off my soapbox and we'll move to questions, but there was what I think was an extraordinary open letter sent to the commissioner of DBHDS, signed by VA CSB, the agency that advocates for CSBs, Sheriff's Association, Chief of Police Association, Hospital Association, NAMI, and a couple others. Organizations that usually communicate a lot, work together a lot, very rarely issue joint statements. And the joint statement was, I think, very well crafted and right on point, and really got down to this. Like, we get why you did what you did with the hospitals, but it doesn't change anything, it doesn't fix anything. It just shifts the burden. And we really need to work together because there are still people in crisis. There's still nowhere for them to go. And we have to figure this out as a collective treatment system, we just can't, do one thing, because all of us, law enforcement can't drive. I mean, we TDO folks to Bristol, 6 hours away, one way. It's insane. I have no other option. So then what? So that's often where we are. Okay, that's my team. That was a long thing. Questions?
Yeah.
Any questions about us or anything else? I mean, I didn't get too much in the weeds on the questions about process and what happens when we don't have a bed. We could go into that more. Oh, here's a good question. Can we use G4S once the TDO is issued, but a request to hold transport is in place? Meaning, can custody, Jane Doe's TDO'd at the end of the 8 hours, but we're continuing to look for a bed. So primary we can't use G4S at that moment yet, and that'll probably stay in place. We'll see. So law enforcement stays with Jane Doe in the emergency room. 5 hours later, I get a bed for her at Poplar Springs. Can we use G4S at that point? The answer is yes, we can. We were not able to initially. They changed the code. This January, last January? Last January. So now we can. Yeah. Or last July. Mm-hmm. So we can. Still the same criteria though. They have to be willing, able, and available. The magistrate has to find it. So we are able to use it in that case and do when we're able to.
Yeah, G4S is only once the person is actually ready to be in motion. Cannot be, at least my understanding, is not available or willing when there's a request to hold. So law enforcement would still have to act or be issued the paperwork without the alternate transport until time to be moved.
All right, colleague. Any other questions from me before we move on?
All right.
Sorry. Okay.
That's all right. Special processes. So inmates, conditionally released violent predators, and conditionally released acquittees. What is all this? So we're going to start off with the inmate. So inmates, and we're talking at the local jails. So ACRJ, if you're in Goochland, Henrico, West, Culpeper Jail, CVRJ, an inmate. We cannot issue an ECO for someone who is in custody. And this also includes, so in custody also includes, let's say, law enforcement, you go and serve a capias on a defendant and you're like, oh, something's not right. And you assess that somebody's in crisis at that time. You can't bring them in front of us you can bring them in front of us for a bail hearing, but we cannot issue an ECO at that point. They are in custody. They are in the officer's custody. And then if we commit them to the jail, either on a secured bond or hold without, and I know I'm using some language that some of you probably don't understand, but if they're committed to the jail, we cannot issue an ECO. The only mechanism for mental health treatment through at least our office for some inmate is a TDO. And we call it an inmate TDO, a forensic TDO. And it's governed by the code section listed here, 19.2, 169.6. The criteria is different. So the criteria is the inmate has a mental illness. There exists a substantial likelihood as a result of the mental illness. It cause harm. So there's the mental illness, harm, but the crux, the difference is that they are not able, the jail is unable to provide treatment in their facility. So that's the difference for the criteria. So somebody can have in a mental health crisis, be experiencing harm to self or to others, but if the jail, can handle it, or it's an appropriate, treatment can be had at the jail, we cannot issue the TDO.
It might sound counter, but we are looking for the least restrictive treatment environment, which doesn't necessarily mean the least restrictive environment for that person's rights or sort of livelihood, the least restrictive treatment environment. And a jail is a less restrictive treatment environment than a state hospital for psychiatric treatment. So our version of that is, if someone at the jail is suicidal, if the jail staff can safely and appropriately manage that crisis, then they wouldn't meet the criteria to be admitted to Western State. What often happens and different jails have different resources, so that that's not going to be the case in from every facility. But what often happens from ACRJ is someone who is acutely psychotic, unwilling to take the medications, and ACRJ is not able to provide medications over objection, will get the person to Western State so they can get the appropriate treatment to mitigate or to deal with the symptoms that they're feeling. I will also say, going back to what we were talking about a second ago with the census pressures, Western is at I think it's 60% of their current admissions are forensic. And that is a very, very, very high number. They're getting forensic admissions right and left. And those they did not stop and cannot stop because, as Avnel says, the state hospital must admit someone who's in state custody. So that even further reduces our ability to provide good treatment for folks who from the community who need treatment at the state or private hospitals.
The petition for inmate TDO can only come from the jail. We have to have a jail officer petition. We cannot issue on our own motion. We get a lot of times family members who are I have a brother, son, somebody, sister is in the jail and they're going through, I just talked to them on the phone. They're going through a mental health crisis and they want to get a ECO or TDO only from the petition from the jail officer. Now we can take information from anybody and we still need to have a pre-screen to issue the TDO. We can take information from anyone, but the jail officer has to petition for the TDO. And if you look at the criteria in relation to that requirement by the code, who else, the code or the legislature decided the jail is going to know if the jail can handle or provide the necessary treatment. That's a criteria. Who is going to be the holder of that information? The jail. So that's the inmate TDO. Conditionally released acquittees. So this is somebody who has been found not guilty by reason of insanity. So you go to court, you found not guilty by reason of insanity, and you're going to the state hospitals, right? You're maybe in Central State for years, decades, then you go to Western State because you're going to be released, and then you're released. You're going to be released with a lot of conditions. This is the process if those conditions are violated or thought that they are going to be violated. So the code says when exigent circumstances do not permit compliance with the revocation procedures upon the sworn petition of a responsible person. So either that the person has violated conditions of release and requires inpatient hospitalization. So we are able to issue an ECO for this type of situation. We have concurrent authority with the court. So you can come to the magistrate's office or you can go to the court. Either can handle the matter. We do not see, I don't think I almost did one, but then the probation officer he was just oh, I can go to the court. And I was like, yeah, you can. But we were looking everything up and so then this person would be ECO to a convenient location for evaluation. So it kind of follows that same procedural process as an adult mental health ECO, convenient location to be evaluated. That should say no officer initiated. No, there is officer initiated authority. Sorry, thinking of medical. So convenient location to be evaluated. There is officer initiated authority in this code section. So it could, sorry, but the code does allow for it, but these these conditions need to be met. And there's a petition. So also just procedurally, the petition for mental health, adult, juvenile, or minor ECO TDO is all the same form, including for this process and an inmate. They're all on the same form. You just check a different box it's the DC 4001 form. And you can find that on the Supreme Court website. If you just go in the search box and put in DC-4001, and this is the same form. So that's that special process that we see very rarely, but you can come to us if you need if we need to get somebody back in custody because they're violating those conditions.
I think, I don't have the numbers on it, but I think the reality is most folks who are on NGRI status are in a hospital. So there's not a high number of folks who are NGRI and in the community. And if they are, it's because they're so far along in recovery that this is not regularly needed.
And I guess the best example, who's it? Ingle, who's living down in like Williamsburg. Yeah, that would be an example.
Right. Anyway.
So then there's conditionally released sexually violent predators. Again, we have concurrent authority with the courts. This is someone who's been convicted of a sexually violent crime and has been released. They're released and they have a bunch of conditions. They're on probation, have a bunch of conditions that they have to follow. If it is that they violated the condition, one of the conditions, then we can ECO them and call it an ECO them, but they go back straight to jail. We're not going to send them to the hospital. They are going to be placed at the local jail so there's a list here of all the people we have to notify if we issue one of these. And then when they all come together and decide what's going to happen with this person, then they'll come to the jail, do an assessment, or I'm not really even sure what happens in the back end, but I have heard that somebody can be incarcerated for a pretty long time waiting for this process to go through. But if they're violating or there's substantial facts that they're going to violate on one of their conditions, then we can issue an ECO. Now, when we've done these in the past, usually the jail is like, well, what is this? It says ECO because the paperwork says ECO, but it's for sexually violent predators and they are to be housed, the code said, at the local jail facility until, like I said, it's the Circuit Court, Attorney General, the Department of Behavioral Health and Science, and the Commonwealth Attorney's Office all decide what's going to happen with this person.
Right.
I want to do questions. We have a couple of questions before medical.
Yeah, I guess. Oh, we do have a question. Okay. Anna says, given the current difficulties, which have really always been difficulties, but have been amplified by COVID, are there legislative changes you think would be helpful to improve the involuntary treatment process? But let's talk about that on another day, Anna. I mean,
it's too much.
The short answer is no. Like what we need is more hospital beds and more resources in the community, not one or the other. I mean, at least in the short term, we do. The ECO TDO process, the civil commitment process, the CSB evaluators, the magistrates training. I think the structure we have, could it be better? Could we find another of the other 49 states? Is there one that has a better system? Maybe, probably. I think our system is fine. It's just we don't have the resources to treat people well, right? So, I mean, there are tweaks in the code, right? I hate what I meant before. I hate that an ECO ends when a TDO is issued. It's just dumb, and it creates all of these problems. That could be easily fixed. I've asked for that. We've asked for that several years, and it hasn't been. At the end of the day, I mean, like whatever. I'd rather there be more funding for community resources and better pay and funding for hospital staff so that we can treat people well.
I have no comment. I can't. I'm a neutral judicial employee. No.
I think she agrees with me.
I've read the other two. So the first one, if law enforcement agency chooses to transport the patient to the initial treatment facility instead of holding off, but a bed is located at the preferred treatment facility later, whose responsibility is it to transport that patient later? So I want to go into the alternate detention facility portion.
Okay.
This used to be like 2 or 3 slides and we took it out. So if some transport commences, one, that negates the ability to change to ATP at that point, once transportation commences. If transportation is commencing to the initial detention facility and the facility changes, CSB, the pre-screener, can change that facility without any consultation or approval from the magistrate's office, and the law enforcement officer who has that person in their custody while before acceptance by the initial facility, has to divert and go to the appropriate facility. You can be halfway over After Mountain, go into Western State, and then go to Williamsburg. If Western or the initial detention facility accepts and then the facility is changed, a new transportation designation is made and a new transportation order is issued by the magistrate's office. But we go back to what we talked about before with transportation. The person, the very first slide that we talked about, is the person now in the magistrate's authority, jurisdiction. So for us, no, because Stanton is outside of our region, Region 4. So then the magistrate, so probably the Augusta magistrate or whoever's on duty for that area would make a new designation, and the 50-mile rule and all of that still applies. So if the person, Western has accepted, and then the person needs to go to Williamsburg, which CSB can still make that designation and make that change, then the Stanton magistrate would say, okay, where does the person live? They live in the city of Charlottesville. How far is the closest boundary of the city of Charlottesville to the city of Stanton? And if that's 50 miles or under, Charlottesville has to come pick them up and take them to Williamsburg. If it's over 50 miles, then I guess that's Stanton PD, or I don't know, the primary law enforcement agency would then have to take the person to Williamsburg.
And also, what she said, period. And then just this question of whose responsibility. I mean, we could ask that about 30 different places where the system can break down because of the lack of resources. And sometimes there's really no clarity over whose responsibility. And that leads to lots of problems. This question, why are TDOs issued, this is for me, why are TDOs issued for facilities that CSB knows are not accepting patients, such as state hospitals? I understand they need to get someone treated, but how does that work legally?
Well, say the TDO's issued. So the magistrate issues the TDO because there's always, per the law, per the code, there's always an accepting facility, that's right. And that's the state hospital. And that's the commissioner's letter or anything did not change the law. That's right.
That's my answer too. Why is it? Because the code requires it. That's it. And legally, the code says, not only says it can, it says it must. If Jane Doe's on an ECO, meets TDO criteria, and there's no accepting facility, the state hospital is the accepting facility. Again, getting back to, but if they don't have a bed and they can't admit someone, then we have problems to solve. But the code requires that we get that TDO and designate that facility, even though they can't.
Practically, it's not. The private hospitals, that's why there's not, because they don't accept, they have that option to accept or not. But for these, the code says that the state hospital must accept, under no circumstances shall refuse somebody who's on a TDO. And so there is always legally, not, I understand not practically, but legally an accepting facility. So we must, and we shall issue the TDO. All right.
We got 5 slides left. And one of those is just our name. So really, we got 4 slides. We're really only 3 because we got this title slide. So yeah. You guys have made it.
Yes. So
although everyone's screen's blank, everyone's eating lunch right now. Except wait, no, Francie, I see you.
Sharita, yeah, she's sticking with me.
All right.
She always does. No, we appreciate you guys and thank you for giving us this opportunity.
For sure.
So medical ECO. So as I said before, there's mental health, adult ECO TDO, mental health, minor ECOs, TDOs, inmate TDOs, no ECOs. Now we're at the, then there's the conditionally released acquittees, sexually violent predators. This is medical ECOs and TDOs that we're going to start. When you think of medical, physical conditions, now medical TDOs also includes mental, so we'll go into that. But these processes, the magistrate can issue only for adults. So no minors medical processes that the magistrate has any authority to issue. So a medical ECO, think of the situation, and I don't know if we have any fire or EMS on the call, but this is fire or EMS gets called out to someone's home and the person is there and has, let's say, fell down and may have a broken hip. But the person says, I'm not trying to go, I didn't call for you guys to come down here. Let's say niece or nephew called. I'm not going anywhere. Maybe they could get a medical ECO to have the person taken to the hospital. Well, to order treatment for the person, because the code's silent on transportation issues for medical processes. So an adult person is incapable of making an informed decision as a result of a physical injury or illness and standard of care necessary to prevent imminent and irreversible harm. Very high bar to get to one of these, very high bar. Imminent and irreversible harm. The treatment needs to be necessary to prevent that. A licensed physician has to petition for this process. So my understanding in talking with like fire and EMS personnel is that they usually have a doctor on call, or we call it ER doctor, and they have to call us to request this. The staff on scene, EMS or medical professional on scene, unless they're a licensed physician, cannot initiate this with the magistrate's office. It has to be a licensed physician. The licensed physician has to give us information of what the injury or illness is, that it needs necessary treatment to prevent imminent and irreversible harm, and what that medical standard of care is what the testing, observation, and treatment are going to be, because we're going to order all of that. Only a magistrate can issue. There's no officer-initiated authority. We have unique authority. Only a magistrate, a judge, no one else can issue this type of process. Again, the respondent must be physically located in the magistrate's region. There's 4 hours to execute. So once it prints off our printer, there's 4 hours to execute, which the code's silent. Really kind of the whole execution part, but 4 hours to execute, 4 hours in custody once executed. This cannot be issued for somebody who's already at the hospital. And there's a whole list of criteria we're going to be looking through when one of these comes through, because it's not often. And we're just going to be checking off the boxes. So there has to be no other person who can make the decision for the person. The person has to be conscious, because the person, it doesn't specifically say that in the code, it is implied, because a requirement in the code is that the person is verbally refusing. So they have to be conscious. So unconscious is not gonna, the person's unconscious because they fell down the stairs and we need to get them in the hospital. Like that, where the person's gonna have to be actively refusing and incapable of making an informed decision. So for both, when we go over medical TDOs as well, a big difference between the mental health and the medical processes is the consent. Unwilling, you can be unwilling for medical treatment. That's your right. It has to be incapable of making an informed decision. Next one, we'll go back. So incapable of making an informed decision. I'm sorry, I must have took it out. There's a specific definition in the code, but unable to make an informed decision. So against medical advice does not mean you're incapable of making an informed decision. I or Kurt or the doctor or somebody else, you may make a different decision, is not incapable of making an informed decision. Septis and unable to, don't even know anything that's going on, that's probably incapable of making an informed decision. But both the medical ECO and the medical TDO required incapable of making an informed decision. The unwilling is not appropriate in medical processes. So then there's medical TDOs. Go back.
I'm sorry.
Yep, that's all right. Medical TDOs governed by 37.2/1104. ECOs were 1103. We have contingent authority with the courts. Another change. For medical TDOs. So the court must be unavailable for the magistrate to act. So again, must be initiated by the licensed physician. So during the day, so right now, if somebody wanted a medical TDO, they would need to contact all of the courts for their jurisdiction to see if they could handle it, or if that get information that they are unavailable. We cannot act unless the court is unavailable. So after 5 and on the weekends, automatic, you come to us. But during the week, If it's not a holiday and it's between the 8:30 and 5, I have to call the courts. No officer initiated authority, no involvement of the CSB unless it was on a psychiatric ECO. Again, no adults, no juveniles, only adults. So the criteria for a medical TDO is that the person is incapable of making an informed decision regarding their treatment, and there needs to be testing, treatment, observation within the next 24 hours to prevent injury, death, disability, or other harm resulting from a mental or physical condition. So this used to be really restrictive, and it said death or disability within 24 hours. And then maybe 2-3 years ago now, it expanded to add the or other harm to the person resulting. Then last year or this year, it was added for the mental or physical condition. It had to be last year, because we've done this a couple times. Yeah. Added resulting from mental or physical conditions. So that means that really opened it up. We still don't see too many of these, but we definitely see a lot more than we did before it was changed when they added the or other harm, because harm could be a lot of things. But again, it's incapable of making an informed decision. So we had a case one time where there was somebody who was at UVA hospital who the doctor called, said they need a blood transfusion or they are going to die within the next 24 hours, must have a blood transfusion. The person had close friends at the hospital saying, no, don't give him a blood transfusion because he's a Jehovah's Witness. And that is the top tenets, no blood transfusion, would rather die before having a blood transfusion. Magistrates have what we call may authority for both of these medical processes, and we do not have to issue even if criteria is met. And in this case, we did not issue. The magistrate in consultation with me made the decision that we were going to utilize that may authority. We don't do it a lot because it's a heavy thing to have a doctor telling you somebody's going to die. And if you don't issue this process, this person will die, and that's what they said, will die, or so it's going to take a lot to override, to use that may authority. But we respected and gathered information that we were confident that this is what that the patient was practicing and that this was the patient's wishes, and we did not issue. The patient did not die. He woke up and we did not issue. I'm not sure what happened on the back end at the hospital, but the patient did not die and did write us a letter a couple of weeks later thanking us for not issuing the process. And it all don't turn out that way, but that's the example of our may authority. So a lot of times we have, almost everything else we do is shall. You shall issue. You shall issue. This is may. This is a big deal. We could order for someone's leg to be amputated. We could, blood transfusion, any medical process that meets this criteria, we have the authority to issue for the ECO, medical ECO or medical TDO. So it's important, heavy business. There's one in the chat box.
Well, that's funny. So I was wondering about mentioning this. So Renee Vance says, are there times when a medical ECO changes the mental health ECO, even with the physician's initiation? So there are ways in which a mental health ECO and a mental health TDO can overlap, or a medical TDO can overlap, not a medical ECO, because again, as Abnel said, a medical ECO cannot be issued for someone who's already at the hospital. But there is a scenario where someone's on a mental health ECO brought to the hospital, and then the physicians make the assessment there that a medical TDO would be appropriate, and they can petition for that. And the code provides some guidance around this. Won't go too deep in the weeds because we're all tired, but it essentially hits pause on the mental health ECO, the medical stuff is taken care of. And then once the medical TDO is resolved, either 24 hours or the condition is resolved or the person's capacity comes back, then the CSB is asked to finish the evaluation. Again, it doesn't say whose custody the person's in or for how long, and it doesn't give details around that, but it does say that they stay in custody. I was thinking as Abnel was talking on that last slide, I almost brought this up. So now that I'm on the soapbox, I'll finish the thought. You know, Anna Mendez asked a question a minute ago, is like, what legislative changes might there be? And I said, I don't know that we really need to do any. And one of the reasons I say that is because of this. 2-3 years ago, there was this, that they put this in, that a medical TDO could interrupt a psych ECO, and they lessened the as she said, lessened the criteria for medical TDO. And there was this great thought by a bunch of legislators and a bunch of decision makers that this is going to save the census crisis, because what's going to happen now is people who are drunk, they're going to be ECO because they're drunk and suicidal, and they're going to be brought in, and then the doctors will get a medical TDO, and then they'll sober up and they'll go home, and all the TDOs will be cut in half because all the drunk people will be released. Well, one, the procedure doesn't play out that easily, and two, it doesn't work that way. You know, I'll go back to like 1,700 evaluations, 1 out of 5 go home, 2/3 are TDO'd. Like, the system is what it is. You can make these little tweaks to the laws and think it's going to solve the census problem. What solves the census problem is having better services for people. So they tweaked the law, and there was this great press release and PR that it's going to fix the thing. We're going to better serve drunk people, and we're going to save the state hospitals. And these little tweaks to the laws are, they take a ton of effort, and they really don't have a lot of payoff in the end. At least from my day-to-day work, it just didn't pan out. So, but yes, there are ways where a mental health ECO and a medical TDO can interact, and we do use that sometimes to the person's benefit. It didn't solve system pressures, but there is a way that those two things can interact.
And let me clarify, a medical TDO can happen at the hospital. So the medical ECO gets you to the hospital. Medical TDO is when you're at the hospital.
So we've run into that. Someone's brought in on a psychiatric ECO because they're delusional, behaving strangely. No one knows why, right? Because they're out in the world, they're behaving strange. And you bring them in, and it's a UTI or it's a blood sugar or something, and then the doctors can get a medical TDO, and we just release the person from the ECO, and they get medical treatment, and everything's all fine. Like that that's not daily, but that's an occurrence that happens. All right, that's all we got. 2 hours 43 minutes. We can take more questions. Or we can all go to lunch.
So a couple of takeaways from this is right here. It's one of the most important slides, if not the most important slide of the entire presentation. And this is Kurt and Avnel's contact information. I have just the utmost respect and admiration for these two incredible people, for their professionalism and also their accessibility. I've called them, emailed them, texted them. And so when there are questions or concerns that you have, I've called them and texted them. Again, Avnel will not give legal advice. Kurt will not give clinical advice, but they will give you a direct answer. Maybe not the answer you want to hear, but the answer that is honest and truthful and to the point. And they will also say, let's figure out how we can make this work for everybody, and most of all for the patients themselves. So again, my compliments, my thanks, my gratitude to Avnel and Kurt for this time, and everybody in attendance for taking time away. If you have further questions or questions that you want to ask privately or personally directly to Avnel and or Kurt, please do. And again, these are extraordinary times. These are horrible times that we're living in right now. And again, we need to be working and communicating as best and clearly as we can together for everybody. Again, if you have requests for the PowerPoint and for this recorded presentation, except for the first 3 minutes of the presentation, which I forgot to hit the record button.
It's the best of my best joke in the first 3 minutes.
Sorry. you can do it again. To that point, everybody.
Tom, can I ask, before you send out the PowerPoint, can I make a change? I want to change that transportation slide that I had messed up before you send it out to everybody.
Correct. And I'm on vacation. So again, I won't have access to my full computer. Okay. So yes, I will send out information and copies to everybody on Monday when I get back to the office when I have 5,423 emails to answer. So yes, please do.
Okay.
And again, everybody stay healthy, stay safe, and we need to work together. All right.
Thank you guys.
Thank you all.
Thank you very much.
Okay, I'm ending the recording session. Hold it. Don't say anything unprofessional yet.